Assalamualaikum warahmatullahi wabarakatuh. My name is Farid Farhan 256338, and today I'm going to speak about one particular case, which is public prosecutor against Chu Chuan Wang. So now we look upon the issue. The issue in this case is whether evidence of bad character admissible under Section 54 of Evidence Act. So the accused was charged for an offence of attempted robbery in the event of which a firearm was discharged by one of his accomplices with intent to cause death to one Ng Yao Sam. The offence charge is provided under Section 3A of the Firearms Act 1971. So the counsel for the defence raised a preliminary objection that the prosecution's case was brought and the accused was denied of his constitutional right to a fair hearing implied under Article 5, Clause 1 of Federal Constitution. At first, held that Article 5 Clause 1 of Federal Constitution does imply in favour of an accused person the right to a fair hearing within a reasonable time. The fact that substantial delays in the disposal of criminal trials is inevitable, as well as the fact that the accused had not made any allegation of specific prejudice. The learned judge subsequently held that the preliminary objection be overruled and the trial to be proceeded. During the trial, the prosecution led evidence to show that the accused was not only an accomplice to attempted robbery but had prior knowledge one of his compatriots was carrying a firearm which would be used not merely to frighten and rob but to the extent of killing. In making his defense by way of the sworn evidence, the accused admitted that he was present. He was present at the material time and place, but he claimed that he was merely accompanying one of the accomplices to look for the latter's enemy and had no intention of attempting a robbery. The accused further argued that he had no knowledge that one of the accomplices was carrying a firearm and that it was discharged at the material time and place. The counsel for the defense made an objection to the prosecution question of whether the accused was a gangster. The DPP further attempted to introduce the caution statement of the accused but was objected by the counsel for the defense. The court held that the question of whether the accused was a gangster is disallowed on the basis that an affirmative answer would be evidence of bad character and such evidence would be inadmissible by virtue of Section 54 of the Evidence Act. This is so as the defense had not adduced evidence of the good character of the accused, nor had the defense impugned the character of any prosecution witness. With the proof of medical evidence, namely a handgun was fired in the deceased's direction, the testimony of prosecution witness Siu Kim, which showed that only one weapon, that is the handgun, was used in the robbery, as well as the fact that it would not have been feasible for the accused and his accomplices to frighten and rob without that particular handgun. The learned judge came to the conclusion that the accused and his compatriots had planned the robbery, and as such, the man who discharged the handgun was carrying the same. Thus, the onus is passed to the accused to prove on the balance of probabilities that he had taken all reasonable steps to prevent the discharge of the firearm concerned. However, the accused bare denial that he was a party to the robbery and his conduct at the scene of the crime could not possibly discharge the onus which lay upon him. Thus, in this case, the accused was convicted and sentenced to death. Alright, now we move on to my recommendation. So my recommendation would be, it is the duty of public prosecutor during the cross-examination to inquire the accused in relating towards the good character of his or hers. The good character of the accused needed to be proven with evidences first. The rationale is to ensure that the bad character able to be considered as admissible later on. The shield shall remain intact. The main purpose is to protect the rights of the accused, since it is irrelevant to show the guilt of the accused and that its prejudicial effect outweighs its probative value. Under Section 54, subsection 1, bad character inadmissible unless good character can be proven beforehand. Then bad character can be considered as admissible. Thus, in this case, before they come out with the statement of the accused as a gangster, they shall prove any elements that the good character of the accused had been adduced or there is a challenge on part of the prosecution witness. Therefore, in this matter, it can be proven by the case of Regina against Winsfield. If the accused chooses to put his good character in court, he must bear the consequences to be cross-examined of his bad character. Although there is a bad character evidences upon the accused, that does not mean that the court can simply neglect to watch upon his good character. Hence, another recommendation is to ensure that the court will not be affected emotionally towards the bad character of the accused. The rationale of this character to be proven is to strengthen the factors which will affect the scenario of the case. Therefore, the mindset of the judges shall not be influenced upon the bad character of the accused. Therefore, in reference to the case above, assuming that if the accused were to be set a gangster and it was admissible and a good character was issued beforehand, such factors shall not affect the judgment of the court as if it is not required in such way. They must ensure that the good character is emphasized too. This is to uphold the fairness and equality on part of the accused position. Another recommendation would be there shall be flexibility of the court to make the bad character of accused as admissible, although there is no good character had been adduced as well as no challenge has been made on the prosecution witness. Regardless, this one relies upon the circumstances of the case. If it is bound to be vital and brings a lot of impact towards the justice, the court shall take this flexible method into practice as illustrated in the case of Wong Fo Hin against public prosecutor. Motive of the person shall be taken into consideration as well. If it is too obvious and overwhelming, might as well the tendency for him to commit another offense which is similar to the previous one will get higher too. As for my reflection, I do find this case illustrated the character evidence in court can be functional towards other cases as well. I do find it is a good reference for the upcoming cases which fall under the principle of bad character and good character under the provision of Section 54 Evidence Act. Regardless, I do agree with the rationale of the bad character to not making it simply admissible because to me, this is a step where we can provide protection unless strongly proven with the offense. It is the duty of the of the public prosecutor to elicit those evidences and to tackle the issue, especially by raising the accused to prove the good character firstly. In addition, the word gangster really reflects a lot of one's character that simply will be detrimental towards the accused if the law does make the bad character to be easily admissible. Although I find that the good character will be beneficial towards the accused, but I am much more convinced that bad character will be detrimental even more towards his position. The bad character evidence will simply be admissible and might affect the position and reputation of the accused straight away. Regardless, Section 54 of Evidence Act is really important and I do not find any complication or issues in regard to them. There are clear-cut provisions which are easily can be understood. I am convinced that the reputation of a man shall be protected and equality shall prevail too. The principles shall remain in this way and the court should be based on it wholly. Even though I mentioned that flexibility can be used too, but that depends on the circumstances of the case. Moreover, in my humble opinion, with the word gangster in the case stated in the case, that really reflect a lot about the character of the accused, which can be detrimental towards his position. In conclusion, character evidence is impactful towards certain cases. However, I beg to differ that it can be standalone, but rather to complement certain circumstances of the case. Thank you so much for watching.